So I'm talking about legal challenges to Australia's plain packaging law. I was in Wellington in late July speaking at an Aspire 2025 event, and there are probably a number of people who were also at that presentation. Can I just have a show of hands? Okay, so I have tried to add some new material, but it's okay if you'd like to take a break and come back in 20 minutes, you can. Okay, so an overview. So there have been three sets of legal challenges, and I'll go through them in this order. Firstly, the challenge under the Australian Constitution, which was resolved some time ago now, and the two sets of ongoing legal challenges in the World Trade Organisation and under a bilateral investment treaty. So the constitutional challenge was brought in Australia's highest court by the four major tobacco companies, BAT, Imperial, Japan Tobacco and Philip Morris. In Australia, if you're bringing a constitutional challenge, you go straight to the High Court, so you don't have to work your way up from the lower courts. I think a number of you have probably already seen over the last few days some of the ads that the industry ran against plain packaging in the lead up to its adoption. Here's one that, one of the features of it was these claims about plain packaging being unlawful and what would happen when it was adjudicated upon in the courts. And here you see the industry saying the government plans to spend millions of dollars on legal fees. It could be forced to pay billions of dollars compensation to tobacco companies for taking away their intellectual property. And here you have another one, BAT announcing that plain packaging is going to the High Court, and I particularly like the last line there, which says, so Scott McIntyre said, "It is no secret that legal experts believe the federal government is on shaky legal ground with plain packaging." The truth was that you couldn't find a person who was both a legal expert and not on the tobacco industry's payroll who thought that the government was on shaky legal ground. I know everyone here knows how this story ends. So the industry's claim under the Australian Constitution was that its property was being acquired without what's called just terms compensation being provided. And the way that the provision in the Constitution works was that if legislation does affect an acquisition of property without providing for just terms compensation, it's invalid. So it doesn't give rise to a right to compensation. So this idea of billions of dollars in compensation was a lie from the beginning. Even if they had won, there wouldn't have been any compensation. So 15th of August 2012, the High Court delivers its orders. It comes as a relief, but it was no surprise. It was the result everybody expected. The court perhaps agreed with this, saw the industry's case in this light. That it was saying that the lawyers are saying, my client's business will die a painful and lingering death, and he deserves compensation. Our customers have a right to die with a colourful package in their hand. Court disagreed. And as yet, I'm not sure that that right has been recognised in any jurisdiction. So the High Court decision turned on this question of what's an acquisition of property. And so it found that the legislation did not confer a proprietary benefit or interest on the government or on any other person. And that was the test under the Australian Constitution. It was a 6-1 victory to the government. So the only thing that legal experts disagreed on in the lead up to the decision was whether it would be 6-1 or 7-0. In the end, it was 6-1. So each constitutional case is particular to its own jurisdiction and jurisprudence. So it's sometimes a little bit difficult to say exactly what this means for similar challenges in other jurisdictions and under other under different sets of laws. So what I've tried to do is tease out what I think are some of the major themes and narratives that you find in the reasons of the 6. And I think these are broadly applicable to legal challenges under different sets of laws. These themes and narratives will be articulated in different legal frames, but I think they'll be fairly common. So I think there are 6 major ones. The first is this idea of negative rights, so that the tobacco company clearly had property, but the property is more in the nature of a negative right. So it's a right to exclude others from using their property rather than a right to use it themselves. The tobacco companies may have lost something of commercial value, but commercial value itself is not the object of constitutional protection. So this is what I like to think of as the so what response. So they say, well, this is going to affect the commercial value of what we do and what we own, and the answer is yes, and so what? What does that mean in a legal sense? The reason that we're doing this is to reduce the number of people who are using your product and the amount of harm that it's causing, and yes, if that then affects commercial value, well, that's just the consequence. Why are you making a legal claim about it? The regulatory scheme is no different in kind from other legislation that requires health or safety warnings, something that we're all familiar with across a range of different products. The requirements of the scheme are just conditions on the sale of tobacco products. So the Commonwealth doesn't use the packaging or the products. If you want to sell these products, here are the conditions that you need to comply with. So they tried to make an argument that the Commonwealth was effectively taking over their packaging and using it for free advertising. So it would have had to, on any other product, it would have had to pay the manufacturer to be able to advertise on its product. Well, the High Court said that that was clearly nonsense. The scheme allows the continued use of brand names, including trademarked brand names, and the ability to use such names is valuable. Marlboro is still Marlboro. Winfield is still Winfield. And this is a kind of broader issue that will be, as I was saying before, it will be teased out in different ways in different contexts. But intellectual property rights are created to serve public purposes. They're not sacrosanct. They don't, once created, operate above or in isolation from other laws created to serve other public purposes. So the fact that you have intellectual property rights is not the end of the story. It's part of the story, but there are other public policy considerations that can be taken into account. 2 things about the decision, if we think about if plain packaging is going to be challenged or is being challenged in other jurisdictions. So the High Court's decision was not in any way a judgment on the merits of plain packaging. So there was no consideration of the evidence in favour of plain packaging. It was a question, could this be an acquisition of property in the way that I described? The answer was no, so there wasn't any consideration of the evidence. That will likely be different in different jurisdictions. And the second is that the FCTC didn't really feature in the decision, but that's because it wasn't needed. It didn't add anything to this question of whether there was an acquisition of property. The FCTC is an important part of the legislation. It's included in the objects. You can see one of the objects is to give effect to certain obligations that Australia has a party to the FCTC, and it's included in the explanatory memorandum, and specific articles and guidelines of the treaty are mentioned there. This will, without doubt, be significant in the international challenges, and I think it's an important part of legislation that when other countries come to develop theirs. So the ongoing legal challenges start with the WTO. The WTO system is state-to-state dispute settlement, so private companies can't bring claims in the WTO. 5 countries have commenced proceedings, and they're at different stages: Ukraine, Honduras, Dominican Republic, Cuba, and Indonesia. They allege various violations. So they allege that the legislation is discriminatory under the GATT. that it imposes technical regulations that are more trade restrictive than necessary, and they allege violations of intellectual property rights, particularly trademark rights. So I'm not going to go through these arguments in detail. Happy to share the presentation, and also happy to refer people to materials that go into them in more detail, including this book, of which I'm one of 3 editors, and I'm always told off for not promoting it. So could somebody just let Andrew and Tanya know that I did promote it in Auckland? And so not surprisingly, the tobacco industry is behind what's happening in the WTO, generously offering their vast expertise and their limitless support to countries who would like to challenge. These are the timelines for WTO dispute settlement. So WTO, one of the features of WTO dispute settlement, which the WTO is very proud of and sees as essential to the way the system works, is that it's very fast. So you can go from the first stage, consultations, mediation, through to resolution, including an appeal, in a year and 3 months. It's a very quick system. However, Ukraine requested consultations on 13 March 2012, and it is now, is it 20 months? More than that, around 19, 20 months later, and we still haven't got a panel composed under this very fast proceeding. And just as the Ukraine has in the last few weeks indicated that it wants to reinitiate a process that it asked be suspended, Indonesia showed up requesting consultations, which is the very first step in that procedure. So if the claimants aren't actually going to bring it on to hearing, it's not such a fast system. And this can go on for a very long time. We recently blogged about this, and we called it "Waiting Out the Legal Challenges to Plain Packaging, Playing into the Tobacco Industry's Hands?" So I encourage you to have a look at our blog. I've recently become a blogger. It's very exciting. If you haven't tried it, you should try it. And I was very pleased to see on Wednesday Minister Turea's speech, and there had been some confusion around the New Zealand position, which had been interpreted by some as waiting to see what the outcome of the litigation against Australia would be. And the message was very clear that New Zealand is moving ahead. It's going to monitor those proceedings as it should. But countries can't wait around on the pretense that there's going to be a resolution of this soon. It ain't going to be resolved soon, if ever. So, on that note, the bilateral investment treaty. So Philip Morris Asia has brought a case against Australia. Under these treaties, the private corporation does have a direct right of action against the government. Philip Morris Asia, interestingly, acquired its interest in Philip Morris Australia on the 23rd of February 2011, which was 10 months after plain packaging had been announced. And then it brought proceedings. How unfair was plain packaging? Who knew this was going to happen? So it's claiming expropriation. This is the idea of it's indirect expropriation. So the legal term is that it's tantamount to expropriation, even though it's not taking the property and using it. It's tantamount to that. And treatment that is not fair and equitable. So this engages concepts like that the investor's legitimate expectations, procedural fairness, transparent and stable environment. So on that issue of legitimate expectations, how could an investor that invested 10 months after the government had announced what it was going to do legitimately expect that the government was going to do what it had 10 months earlier announced it was going to do? Who can operate in those sort of circumstances. Our lawyers have come up with a great trade agreement. Is that the one where we trade our soul with the devil? I think Tandberg has enjoyed these proceedings. This is a very strange system, the bilateral investment treaty system. So an ad hoc tribunal is established. There are no appeals. There's not a single unified body of law. And the hearings, meetings and conferences are held in camera, and their transcripts are held in confidence. This is very hard for people who are used to the open justice that we see in domestic court proceedings to understand how and why proceedings take place in this way. Each party may publish the documents it has filed in the proceedings, as long as it notifies the other party of its intention and allows the party to designate parts as confidential information. Philip Morris Asia argued against even this, so it didn't want the Australian government to be able to decide to release its documents. The timing. So the next step in this proceeding is in February 2014, there's a hearing in Singapore where Australia's request for bifurcation will be considered. So this bifurcation means that Australia's arguing that its objections on the grounds of jurisdiction should be heard first, and only if the court agrees to exercise jurisdiction should we get to a hearing on the merits. So Australia says, in part because this is an abuse of rights to invest after the decision's been made, and then to use the treaty that you otherwise wouldn't have had access to is an abuse of rights. The court shouldn't exercise jurisdiction. So this is February 2014. This is only on the question of whether it should be bifurcated. And after that, well, it depends what the tribunal decides. So we might get a decision on that in the second half of 2014. If the tribunal says it'll hear jurisdiction, then we'll have a hearing on that, and then we'll wait 6 months for a decision, and then there'll be submissions, or if it decides, anyway, without going through all of those permutations, 2015, 2016, maybe beyond. Philip Morris, that should be Philip Morris Asia, PMA, filed its notice of claim in June 2011, filed its notice of arbitration in December 2011, and we're talking about 2015, 2016 or beyond. Merits of the claims. Australia is confident in its position. It's no secret that the overwhelming majority of expert opinion expects Australia to win. And I'm trying to condense some complex legal arguments into a single soundbite, which goes against every fibre in my professional being. But I think, and it's no secret that the overwhelming majority of expert opinion thinks, that Australia's law is a sound exercise of its sovereign power to regulate. It's non-discriminatory, it's based on evidence, and it's well drafted. It has behind it the legal and political force of the FCTC, its Article 11 and 13 guidelines, other decisions of the Conference of the Parties, and other international instruments, including the Doha Declaration on TRIPS and public health. So what are some of the things at stake in these international challenges? Well, they're in part about governments' right to regulate. So it's partly about their right to regulate tobacco. It's partly about the significance, legal and political significance of the FCTC. So you have an international treaty which has 177 parties. A party to that treaty is implementing its obligations under it. And there are really important questions about the relationship between that treaty and the WTO treaties and bilateral investment treaties. And it's a broader question than tobacco, so these are broader public health questions, and not just public health, public interest, so environmental protection, a range of other areas. So how are non-health expert tribunals going to approach public health evidence? We can't expect the sort of people who sit on these tribunals to master behavioural science or epidemiology. They need to engage with the evidence that's presented to them in a way that respects the way that other disciplines understand and make sense of the world, and not apply narrow legal concepts that make sense if you're talking about evidence in cases like, well, murder or assault. So who did this to who? And then the kind of evidence that you talk about in that context is very different from the kind of evidence that you look at when you're talking about these high-level population health measures. And the integrity of the international system, and I use that word deliberately. So integrity is about how things fit together, but it also has that other meaning that we're more familiar with. Does the system have integrity? And for that system to survive, it's no secret that independent experts think that system has to show that it can live with and accommodate other important public health and public policy considerations, particularly those that are articulated in a treaty with 177 parties. That's what I had to say. It's right on 9 o'clock. So to reiterate, I think people think that Australia is going to win these cases. Other countries can't just wait forever until these are resolved. And there's a lot to learn from the Australian experience. And I've had this conversation with a couple of colleagues recently, that just having been involved in this and working with other lawyers, academics, and not just lawyers, but I'm looking around the room, those who are doing the research that this is all based on, both the policy and the defence of the legislation. So the amount that we've learned since we first looked at this is a resource that's now available to everyone. So even this idea of something like, what's the right to use? The first time we had this conversation with a leading expert on trademark law, he hadn't given thought to all of the things that he's given thought to over the couple of years and now published on. So our experience has really, I think, created a wealth of expertise and knowledge that's available to the rest of the world. Go New Zealand. New Zealand's a really great guy, to quote the chair. Thank you very much.